According to the National Highway Traffic Safety Association statistics, an average of 12,000 people die every year in DUI-related accidents. An average of 900,000 people are arrested each year for DUI, DWI, and a full one-third of those are repeat offenders. While the national average has dropped by half over the past 35 years, there is still an ongoing problem with drinking and driving. Drunk driving happens when a person is driving an automobile after consuming alcoholic beverages to the point that their ability to operate a motor vehicle is impaired. The jury must be convinced beyond a reasonable doubt that the person's blood alcohol content, BAC, exceeded a certain amount to find a person guilty of DUI. In most states, the legal limit is 0.08, or 8%. Car accidents are the leading danger when you drink and drive. Consuming too much alcohol will impair your ability to use your common sense and think long-term. It results in impaired vision and loss of judgment and alertness. Reduced muscle coordination and impaired perception make it harder to detect and react to dangerous and emergency driving situations. Slowed mental processing ability results in a substantial inability to control the vehicle, maintain lane position, and brake appropriately. When you decide to get into a car after having too much to drink, you not only put yourself in danger, but you jeopardizing the safety of everyone else on the road. When someone is severely injured or killed due to one person's choice to drive under the influence, the impact is monumental. The victim may be left permanently disfigured, paralyzed, unable to talk or feed themselves, brain injured, etc. That victim may require constant care for the remainder of their lives. The victim's family may be left grieving the loss of a wife, husband, son, or daughter, and could be left with no breadwinner to provide for their needs. Many states have taken steps to prevent or reduce drunk driving behavior, such as punishment through stricter legislation and harsher consequences to penalize intoxicated drivers. Harsh penalties for BAC test refusal. All states have laws prohibiting motorists from operating a motor vehicle with a blood alcohol concentration, BAC, exceeding a specified level. The BAC is typically determined through a direct analysis of a blood sample or by using a breathalyzer machine to measure the alcohol in a person's breath. All states have implied consent laws, which require drivers to submit to BAC tests. Most states impose a misdemeanor penalty of a suspended driver's license for refusing a BAC test. Some states, such as Minnesota and North Dakota, have increased the punishment and made it a crime to refuse BAC testing. License restrictions. Under Arizona law, if you are pulled over and the officer asks you to take a blood, urine, or breath test, you must comply. In Arizona, you automatically consent to blood alcohol content testing whenever you apply for and acquire the right to operate a vehicle. The implied consent rule in ARS Section 28-1321 states that when a law enforcement officer suspects you of DUI and you refuse to permit them to conduct a BAC test, you will be required to surrender your license, and it will automatically be suspended. In Arizona, any person driving or in physical control of a vehicle while intoxicated by alcohol or drugs is breaking the law. Arizona revised statutes states that being under the influence means being impaired to the slightest degree. The alcohol content level found in your blood will increase the fines, jail time, and other penalties if you are convicted of DUI. Arizona recognizes 3 levels of blood alcohol content and assigns penalties accordingly. Basic DUI. A basic DUI is where your blood alcohol content is between 0.08% and 0.14%. Extreme DUI. An extreme DUI offense is if you are caught driving with a BAC of 0.15% or higher. Super Extreme DUI. A super extreme DUI offense is if you are caught driving with a BAC above 0.20%. This level is the highest level DUI charge in Arizona. Driving with a BAC of 0.30% or 0.40% would still be considered a super extreme DUI and are still misdemeanor charges. Penalties for super extreme DUI in Arizona. A person's first Super Extreme DUI requires the offender to pay a $3,250 fine, along with other fees and jail costs. The offender must serve a 6-month jail term, and driving privileges are suspended for at least 1 year. An IID will be installed and remain in place for 2 years. After any previous DUI conviction, a second Super Extreme DUI conviction carries a $3,750 fine, along with other fees and jail costs. The offender must serve 6 months in jail, and their driving privileges are suspended for at least 1 year. An IID will be installed and remain in their vehicle for 24 months. A Super Extreme DUI charge is not something you should handle by yourself. You will want to speak with an Arizona criminal defense attorney experienced in DUI law. An experienced attorney has the knowledge, training, and experience to investigate the circumstances of your arrest, ensure your rights are protected, and defend you against charges of drunk driving. Schedule a free consultation today. If you're facing charges relating to a DUI, you might want to understand Arizona's law and secure the right legal counsel to ensure a fair trial. Call the Phoenix DUI Lawyer Criminal Law Team at 602-900-9891 to get expert-level legal help with your case.